Possession and Access Enforcement. El Paso County Domestic Relations Office.
Access and possession enforcement with the DRO. Topics to be covered. Goals. How can applying for access and possession enforcement help me? Application process. Family Court Services Division. Legal Division / Friend of the Court. Court. And questions.
Goals in possession and access enforcement. Our goals in enforcing possession and access align with the policy of the state. It is the policy of the state to encourage frequent contact between a child and each parent for periods of possession that optimize the development of a close and continuing relationship between each parent and child. How can applying for possession and access enforcement help me? Family Court Services of the DRO will speak to both parents and attempt to help the parties resolve the challenges preventing them from having the court-ordered access and possession time. If the case merits a motion to enforce, the DRO may request make up time for time you were denied visitation, clarification of the access and possession order, contempt for the parent not following the access and possession order. This could include community supervision and/or jail time. What is not possession and access enforcement with the DRO? Not a change of custody. Not a change in your court order of possession and access. Not a change in geographical restrictions. Does not involve child support. Requirements before you apply. You must have a court order that gives you possession and access to your child. You must have followed your court order and attempted visits at least 3 times, on the date, time and place stated in your court order. You must have been denied visitation on the date, time, and place as stated in your court order. How to apply? Number 1. Go to the DRO website and click the Getting Started radio button on the top right to access forms. Number 2. Scroll down to the section that says Application to enforce access and possession rights. Number 3. Click on the PDF version or Google Form version. Number 4. Fill out the application. Number 5. Submit the application to the DRO. Number 6. Complete the online court order orientation video. This is found on the DRO website, under the Family Court Services radio button. Number 7. Gather evidence that can help prove your visitation attempts. What happens after I apply? The DRO will review to see if you meet the requirements for possession and access enforcement. The DRO will review that you filled out the application completely. Fill it out even if it sounds repetitive. If you do not fill out the application completely, the DRO will not know if you qualify and may deny your application. Incomplete applications may make you seem like you do not qualify and the DRO may deny your application. If your application is accepted, Family Court Services will contact you and the custodial parent to attempt to resolve the situation. If your application is denied, the DRO will send you a denial letter explaining the reason for the denial. What happens after I apply? Continued. If the Family Court Services Division is unable to resolve the situation, then the case will be transferred to the Legal Division / Friend of the Court. The Friend of the Court will review the case to see if it merits court action. The Friend of the Court will review the evidence you have of the denied visits and will look to see if you followed your court order when you attempted those visits. If the Friend of the Court believes all the legal requirements are met, court action will be initiated. Some reasons your application may be denied. The court order does not say you have access and possession rights to the child. There is pending litigation involving that child. Child Protective Services has an open case involving that child. Your order is not enforceable. You did not follow your court order. Your visitation attempts were not according to what your court order states. Family Court Services. Family Court Services. Family Court Services will communicate with both parents to help them resolve the situation without the need for court action. Family Court Services is comprised of highly qualified and experienced professionals, trained to resolve access and possession and parenting problems. Parents should make every effort to resolve issues outside of the courtroom. Court action should be a last resort and does not always resolve the conflict. Parents will be required to take the court-ordered orientation and/or the cooperative parenting class. Why not skip Family Court Services and go straight to court? Court is not quick. It may take a few weeks to several months to get a decision from the court. It depends on the case. If the case is appealed, it may take even longer to get a final decision from the court. Court is unpredictable. The judge may deny the enforcement or may order something different than you expected. The enforcement process with the court is more complicated than it seems, and even if you are sure the court will rule in your favor, that may not be the case. Court can be costly. There are attorney's fees and court costs involved with filing a case. You may also have to take time off from work to attend court hearings. What happens if I am still not allowed visitation after talking to FCS? If Family Court Services is unsuccessful in resolving the situation, then your case may be referred to the legal division friend of the court. Although resolution through FCS is often better for your family because of what was discussed in previous slides, resolution through FCS requires parents to cooperate. Court action should be a last resort, but sometimes court action is what helps parents get visitation when nothing else worked. Legal division / friend of the court. Legal division friend of the court. An attorney will review the case to see what court action can be taken, if any. FOC will contact you to request what dates, times, and location you attempted to pick up your child. These attempts must comply with the court order. FOC will request to see any evidence you have of the attempts you made to pick up your child. If you do not have any evidence, your application may be denied. Remember, follow your court-ordered visitation dates, times, and location. If you are not following your court order when you try to pick up your child for visitation, don't expect the court to punish the other parent for denying visitation. If you are not following your court order when you attempt to pick up your child, the DRO might not take the case to court. Legal division friend of the court. Continued service. Once the motion to enforce is filed, the parent denying the visits will need to be served with the legal documents required. If the DRO does not have a reliable address to serve the parent who is denying the visits, then the DRO will be unable to continue with the enforcement. Cooperative attitude is very important. We want to help you, but we are unable to do our job if you refuse to provide us the needed information or refuse to testify in court. The more you cooperate with us, the better we are able to do our jobs. What can help the case? Follow your court order. Arrive on time to pick up and drop off your child. Evidence of attempted visits. Police reports. Bring a witness with you when you attempt visits. If pickup and drop-off location is a store or a restaurant, purchase something from the store or restaurant so that you have a receipt that provides a record of the date and time you arrived to pick up your child. Be respectful when you go to pick up or drop off your child. What should I do after the case is accepted with the DRO for possession and access enforcement? Continue to follow your court order. Be respectful during your visits with the child. If the other parent gets hostile or violent, do not engage and leave immediately. Comply with the DRO requirements. Continue to communicate with the DRO. Court. You will need to testify. Your witness will need to testify. The other parent will have the opportunity to testify. The other parent has the right to an attorney. Is the DRO my attorney? No. If you feel you need an attorney to represent your interests, you should hire an attorney. The DRO does not represent you, does not represent the child, and does not represent the custodial parent. Even if the case is taken to court, the DRO attorney represents the interests of the state of Texas, not you, not the child, and not the custodial parent. Why do I need to testify? If the case goes to court, you will need to testify about the dates, times, and location you attempted to pick up your child. These attempts must comply with the court order. This is your opportunity to have the court hear your side of the story about the denied time with your child. The other parent will have an opportunity to tell their side of the story as well. It is important that you tell the truth in your testimony. You will be under oath. Remember, the DRO attorney does not represent you and will not be telling your side of the story to the court. You will have to do that through your testimony. Questions? If you have additional questions, you can contact the DRO through the phone at 915-834-8200. Or you can email the DRO at domesticrelations@epcounty.com.